Be ready. 5 seconds. Start. Before independence, Section 124A of IPC was extensively employed by the British to suppress the Indian nationalist movement. In Joginder Chunder Bose, the accused was charged with sedition for criticizing the Age of Consent Bill and the negative economic impact of British colonialism. While directing the jury on the case, the court distinguished sedition, as was understood under the law of England at that time, from Section 124A of IPC. It was observed that the offence stipulated under Section 124A of IPC was milder, as in England any overt act in consequence of a seditious feeling was penalized. However, in India, only those acts that were done with an intention to resist by force or an attempt to excite resistance by force fell under this section. It was opined that Section 124A of IPC penalized disaffection and not disapprobation. Disaffection was defined as a feeling contrary to affection like dislike or hatred, and disapprobation as merely disapproval. The following interpretation was ascribed to the term disaffection under Section 124 of IPC. In Queen Empress versus Bal Gangadhar Tilak, the defendant was accused of sedition for publishing an article in the newspaper Kesari invoking the example of the Maratha warrior Chhatrapati Shivaji to incite overthrow of British rule in India. In this case, Justice Stretchy placed relevant materials before the jury for interpreting disaffection by saying, the interpretation that only acts that suggested rebellion or forced resistance to the government should be given to this section was expressly rejected by the court. This judgment influenced the 1989 amendment to Section 124A of IPC, wherein the added explanation defined disaffection to include disloyalty and feelings of enmity. A similar interpretation was given to disapprobation in Amba Prasad, wherein the accused had been booked under Section 124A of IPC for publishing an article in a newspaper called Jami-ul-Ulama. The court, after analyzing the meaning of disaffection, held that any disapprobation will only be protected as free speech if it did not lead to disloyalty or subverting the lawful authority of the state. The court remarked, following the literal interpretation of Section 124A of IPC, the court categorically held that it is not necessary that an actual rebellion or mutiny or forcible resistance to the government or any sort of actual disturbance was caused by the act in question. Stressing this point, the court remarked, these cases brought to light the ambiguity being created by the explanation in interpreting the term disaffection. In order to remove any further misconception in interpreting Section 124A, the legislature introduced explanation third to the section, which excluded comments expressing disapprobation of the action of the government but not intending to lead to an offence under the section. The main intention behind adding another explanation was to make the law more precise. The Select Committee, while considering the law of sedition, explained this addition in the following words. The discussions of the Select Committee indicate that the British government was not keen on granting freedom of expression to Indians to the extent enjoyed in England. Stop.